and you can speak. So I'll start with the ladies. Can I start with Amira, please? You're on mute, Amira.
Thank you, Emilia. You're stunning, by the way. You look gorgeous. So I'm Amira Mahmoud of AM Attorney in Paris. I'm a French and Egyptian qualified lawyer. I've spent a little over 20 years as a counsel and arbitrator in cross-border commercial and investment disputes across Africa, Middle East, Europe, and Latin America as well, and mostly in energy construction and infrastructure. I also serve as a deputy representative of the APA, which is the Association of Promotion of Arbitration in Africa.
Thank you very much, Amira. Terry, can I invite you to please unmute and introduce yourself?
Thank you, Emilia. Good evening. It's 7 p.m. here in Nairobi, so evening or afternoon, depending on where in the world you are. It's a pleasure to be part of this panel. My detailed information is in the link that's been shared in the chat, but just by way of brief introduction, I'm a dual qualified solicitor in Australia, New South Wales, and an advocate of the High Court of Kenya. I'm also a fellow of the Chartered Institute of Arbitrators, and I'm looking forward to the discussion. Let me allow my fellow colleagues to introduce themselves as well. Thank you.
Thank you very much, Terry. I'm going to now invite Faisal. Please, can you introduce yourself to us?
So first of all, thank you. First of all, I'd like to thank you, Professor Emilia, for inviting me to join this distinguished panel. It is such a pleasure. I'd also like to extend my gratitude to the audience who have taken the time to attend. My name is Faisal Mouminah. I work for MBL, who's a leading construction contractor in Saudi Arabia, as a chief commercial officer. At MBL, we mainly construct building, infrastructure, and marine works. My educational background is a combination of engineering, law, including Islamic Sharia and arbitration. In my career, I worked for consultants, developers, and contractors. At MBL, we mainly do projects in Saudi Arabia with some projects in Northern Africa. That's me.
Thank you very much, Faisal. Barry, first, please, can you tell us where you are? Are you in the Caribbean so we can become jealous?
Or I am in the Caribbean, and if you want, I can turn my camera around and show you the sea.
Don't be kind.
Also, it's compared to most of the rest of the world, at least in Europe and North America, the weather's very pleasant here, cooler, and not some of the things that people are getting in Europe and Canada, the US. So I'm an independent arbitrator and mediator. That's largely what I do. I work everywhere or anywhere. I'm affiliated with 33 Bedford Row Chambers in London, Arbitration Place in Canada, and Caribbean Arbitrators. The sort of short background is that I worked as counsel and doing disputes in Canada for most of my career, litigation, and then it transitioned to being all arbitration. And then for 3 years, 2015 to 2018, I was the commercial court judge in the British Virgin Islands. There's a significant commercial court which deals with parties from really all over the world that have incorporated in BVI. So, and since then, I've been, as I said at the beginning, an arbitrator and mediator.
Perfect. So now you know who our speakers are. So we're going to dive into our webinar. Well, we have 4 major questions that we want to engage with to help us unpack this whole issue around dispute avoidance. But what we find is various people use dispute avoidance to mean different things. So we'll come to define what we mean for our purposes, for the purposes of the panel discussion this evening, or afternoon, or morning, wherever you are, what we mean by the term. So for now, we want to start with Faisal, and we want to know what types of disputes are you seeing? Well, you are in-house, so what sort of disputes is your company having to deal with?
Thank you, Emilia. So, given the fact that I work for a construction contractor in Saudi Arabia, and my background as a construction professional, my practice mainly focuses on construction and energy disputes. In this context, I would say that the vast majority of disputes we are now seeing tend to arise from certain common construction contract provisions with common patterns. And that is what I'd like to reflect on in this session in regards to this aspect. For example, provisions regarding payment are common ones. In fact, it was once said by Sir Michael Latham in his famous report that cash flow is the lifeblood of the construction industry. Surely contractors, subcontractors, and suppliers alike rely heavily on steady cash flow to settle their obligations. In here, I'm not merely referring to the very basic question of whether a payment is made timely or not. Conflicts, in fact, may arise relative to the valuation of the works. What is considered payable under preliminaries versus permanent works, and many other payment implications. These can get quite complex and can lead to conflicts, and if not managed well, eventually end up in disputes. Valuing claims is another one, especially prolongation. If the contract is silent on the method of delay analysis, parties may argue as to what is the most suitable method for use in that particular instance. In reality, out of the vast majority of contracts I've come across, I've seen very few contracts where the method of delay analysis or any guidelines in this regard are prescribed. Then, unfortunately, once the quantum of the delay is agreed, we then tend to argue about the monetary aspect of the claim. Two very common arguments tend to arise in here. One is that should the contractor be compensated on the basis of rates stipulated in the preliminaries for time-related items? That is one approach. Or another approach, should compensation be based on actual cost? If we look at the literature and best practice, Society of Construction Law protocols stipulate actual costs as the basis, but surely not all clients, especially here in the Middle East, are happy to do so just because of the mere fact that a publication was issued in the UK by the Society of Construction Law says so. The other aspect then is whether the contractor should be compensated for the period when the delay took place, or should they be compensated for the period when the project got extended? That is a very common cause of conflict. The former, in fact, is what the SCL, Society of Construction Law Protocols, suggests. But again, it is difficult here in the Middle East region to bind client to that narrative when the contract is silent in relation to such provisions. Design obligations and fitness for purpose are other common arguments, especially in design and build contracts. Questions very often arise in relation to what is deemed to be a change and what is to be design development, falling under the contractor's design responsibility. Again, what is considered reasonable for an experienced contractor to allow for? So all those arguments are very common fertile grounds for conflicts, and as I said, if not managed well, can lead to dispute. Finally, I would say in order for parties to be able to resolve these matters, they need to be able to participate in a give and take discussion with a view to reaching an amicable settlement, and this must not be seen as a unilateral, one-sided deal.
Yeah, thank you very much, Faisal. So what I hear you say is it's not enough to just have a contract. So you can't just, we've always said, you can't just borrow one of the FIDIC contracts and then just adopt it. And one of the key things you're saying is that clarity with contractual provisions is important. So things shouldn't just be left hanging on, and then when a dispute arises, it becomes really difficult to manage. The other thing you've said is that it's important to understand regional sentiments and flavors of the players. What will be acceptable to the players in the particular region? I know that your company will do a lot of international work, so that must be a little bit complex thinking through with your hat on and who your counterparty is. Thank you very much for that detail. I'm sure we're going to come back because, of course, the issues around the Iran war and what's going on currently in the Middle East would also impact on some of these contracts and some of the transactions that your company is already is working on and has signed. So Terry, I want to turn to you because you are not in-house, but you are the first port of call. So what sorts of disputes are you seeing? Are your clients coming to you with?
Thank you, Emilia. Yes, not in-house, but having to also navigate the disputes that particularly not just in the building and construction sector, but we're seeing a lot of increase in disputes around the extractives and mining sector, geothermal projects, energy, and other related projects surrounding infrastructure. That, of course, is tied up with the move of the Kenyan government trying to facilitate more ownership among the Kenyan population for what are deemed to be natural resources. So particularly in the power and energy sector, we've seen a lot of increased movement. What has been quite interesting to see, and I'll just briefly touch on a couple of examples. For example, the Kotek mining case, which I think a number of us on the call are aware of, which really highlights how a complex dispute involving a cross-border arbitration can raise very significant investment claims. And in that particular case, the allegation was that the claimants had failed to comply with the regulatory regime in Kenya, with the results that the claim was dismissed, and highlighted the fact that the tribunals are willing to take the position that if local law is not complied with, and in this particular situation, which was a mining investment by Kotek, that tribunals will not uphold any claims related to the failure to comply with local regulatory regimes. That particular arbitration was a bilateral treaty arbitration, and it was under ICSID. Another one, which I'll give an example of, and maybe some of the East Africans in the room on the platform may know about, is the Kinangop wind power project. Sorry, it's late in the day, maybe it's starting to show, but the Kinangop wind power project, as the name would suggest, this involved an infrastructure project around wind and geothermal investment. And the claimant or the investor alleged that their project was compromised by government interference. And that had manifested itself by a lot of protests by the locals who felt that they had not been consulted. The project had been undertaken in a manner that did not facilitate public participation. And of course, there were concerns about land rights. the government denied the allegations by the investor that it had facilitated political unrests. That particular claim, again, was dismissed on the basis that there was no proof by the claimant that there had been political unrest facilitated by the government of Kenya. So in brief answer to your question, and when we do touch on the question around the building and construction sector in particular, the situation in Kenya, I think, is slightly different in that, yes, whilst we have a lot of money that's being poured into the infrastructure and building and construction sector, we are seeing more increase in multilateral and cross-border related arbitrations and disputes. And as we continue the conversation, I will have occasion to perhaps talk about how we are seeing parties trying to mitigate against such situations. Thank you, Emilia.
Thank you very much. And which is really interesting because we're beginning to see disputes arising from renewable energy projects and the environment. And one of the things that I'm big on is the engagement of local communities, especially for huge investment projects. And we know that there's a growth in mining cases. It will be interesting, of course, engaging with how this would impact on the movement towards renewable energies. Barry, turning to you, what sorts of disputes are you seeing in your practice?
There's a quote from President Lyndon Johnson of the U.S. who said he's got a door practice. Whatever comes in the door is what he's doing. And as an independent arbitrator and mediator, it tends to be somewhat that way. So I deal with a wide range of disputes in terms of the subject matter, the location of the parties, the industries, and the legal areas. And it really, over the years, I've probably done things in most sectors and most areas of the law. The big difference between the two areas in which I work, arbitration and mediation, are really two very different processes for the parties, for counsel, and certainly for the neutral. As an arbitrator, you're doing very different types of work, as most people will know, and in very different pressures, very different skill sets involved, and being able to do one or being good at one doesn't necessarily make you good at the other. Overall, I tend to describe what I do as commercial disputes, broadly defined, and that's really business related. So often I'll describe what I do by talking about what I don't do, the areas of law or the kinds of disputes. But almost by definition in our arbitration, most arbitrations on the non-investor state side are going to arise from a contract, and often the issues are interpretation of the contract, issues around performance, issues around breach, and of course issues around relief, particularly damages. They arise often in joint ventures, in shareholder situations, disputes between shareholders or among shareholders, between corporations and the shareholders of that corporation, those kind of intra-corporate disputes. But in terms of the industries or the sectors, I really will see work in construction, so I can relate to the things that Faisal is talking about. In energy and mining, IP and IT, the service industries, pretty much all areas may come up, and I've got experience dealing with them. I think the other thing that I'm finding, just to bring it towards trends and what's happening, is in the arbitration work that I do, and again, many will know this, we're seeing more innovation. The institutions have innovated with their rules in terms of expedited processes. On tribunals, there's more interest in procedural innovation, tailoring the procedures to fit the disputes, to be efficient and cost effective. And I think we're seeing, at least in the parts of the world where I work, more mediation. In Canada, where I practiced as counsel, mediation, there's been mandatory mediation in most of Ontario for over 2 decades, and it's very much accepted. So it's interesting to see as other parts of the world increasingly use mediation, either because it's being mandated by courts, but voluntarily as part of the dispute resolution process. And that sort of leads us to the main topic for today, is where mediation is being used, not only where there is a dispute, but to avoid or prevent or nip in the bud disputes. And the last thing I'll say, just picking up on something that Terry spoke about, is I think there's an increasing role where you have larger projects for the mediator role in dealing with the local populations, the local issues, the non-parties to the contract. And that's true in commercial situations, and of course, particularly so in investor situations, investor state situations.
Great. Thank you very much for bringing the perspective of the neutral. I think sometimes newbies forget that as independent neutrals, we do not really do any marketing. And we don't market, we're not counsel. We don't go out there asking for appointments. There's a nice way to do it. We just don't do it very openly. So thank you for linking with those. And again, this whole idea of commercial, the commercial nature of the transactions that you're seeing in your practice. And bringing into view the role of institutions and the changes we're seeing. Quite a number of institutions are looking at their rules and trying to see how they can be more efficient. And we will come to AI and see how that might aid with that. And of course, you've already thrown in the word mediation, so people know what to expect. Amira, yes, what are you seeing?
Just a side note, just in France, councils are prohibited from marketing. It's not like the US. It's illegal.
We now know what happened to the French football team, but let's carry on.
It explains a lot. So for the disputes I usually work on in cross-border projects, most of what I see, Emilia, is not about who is right. It's mostly about the disruption itself, meaning payment or currency shocks or shifting in conditions after long-term infrastructure projects or force majeure aftershocks. So to put some categories on it, on the commercial side, many are related to construction and infrastructure claims over delay, variation, or cost overruns. For the energy dispute, for overpricing, for example, or tariffs and change in law, or shareholder fallout. So when a project underperforms, for example. And on the investment side, treaty claims against states, often triggered, by the way, by a revoked license or a permit or a regulatory shift. That change can also be a change in the fiscal terms. So what begins as a request to adjust a price or a situation or a deadline hardens into a claim of breach. The legal disagreement is usually the last symptom. It's not the cause. And you would be surprised that a striking number of these matters could have been contained if the first exchange between the parties have had been handled differently. So I think this is how I define the kind of disputes from the perspective of the avoidance of it. But we'll get back on this while exploring the meaning and the tools that we may use to prevent it.
Yes, I was wondering, why don't we stick with you so that, because you've already started engaging. I know that Barry was meant to kick us off, but you've already started engaging with dispute avoidance, and I know that you're thinking in terms of the larger picture and setting that context and looking at
Exactly.
some cultural views. Do you want to sort of set that out for us?
Well,
Then I'll come to Barry.
yeah, with pleasure. So actually, as we are speaking about the dispute avoidance, we're speaking about two terms, actually, the disputes and the avoidance. So the dispute avoidance is often misunderstood with preventing disagreements from arising, which is completely fictional, because disagreements are inevitable on long and complex projects. The objective is not to eliminate the conflict, but to stop it from hardening it into a formal dispute. We are always talking about dispute avoidance, but we are not meaning by this disagreement avoidance, because not every disagreement should become a dispute, actually. And in many African and Middle Eastern business environments, this is the old ground. When circumstances change, renegotiation preserves the commercial relationship rather than abandoning the contract, closer to performing it than breaching it. So management begins at the first sign of contractual stress, not when a notice of arbitration is filed. So which raises the real question underneath all this: when does a commercial problem actually becomes a dispute? It's usually not because of the underlying event, but because of how the first request for an adjustment is communicated and received. Because a renegotiation, even meant in good faith, can land as a threat. I would say you need to handle that first exchange well, and the dispute often never formed. So this is what I would give as a definition for the avoidance of dispute avoidance.
Yeah, I think that is really helpful, setting out clearly, maybe stepping back and saying to ourselves, we can't avoid conflicts, we can't avoid disagreements. Even an individual, yesterday I was in Paris teaching on the academy, and I said to them, an individual can have a disagreement with themselves. It's just you. And you look at yourself in the mirror in the morning and you're like, I don't like what I see. That's a disagreement. But then, you don't divorce yourself because you can't. And so I like the idea of clearly defining what exactly, at what point in time does a dispute happen? Is it any difference, any allegation, any disagreement, and how we can deal with that? So Barry, I turn to you to help us again with this definition. What for you are we talking about?
Well, the terminology sometimes gets in the way, and when we're talking about dispute avoidance, but what we're really talking about, and I'll sort of pick up on what Amira said, is spotting emerging disputes, spotting situations that could escalate into disputes, spotting them as early as possible, and then trying to, I used this expression earlier, nip them in the bud. That is, deal with them before they escalate, before they become more problematic, before people get angry with each other, take more formal positions. So the process is intended to have the emerging disputes identified and then dealt with. So the systems can be different. Probably the most sophisticated, but also the most expensive, would be on a project where you anticipate there will be disputes or the potential for disputes. So those would be two kinds of situations at least. One, the construction project kind of situation. The other is just ongoing projects, relationship projects, or non-transactional situations in all kinds of areas. So with distributorships, joint ventures to develop a product, a technology, it's two or more companies working together, and all of those over time have these potential. So ideally, where it can be justified, you have people right from the beginning. It's a provision of the contract that there will be one or more than one, two or three, I'll call them mediators, but people who follow the contract, are familiar with what's going on, and are really on standby to step in whenever one of the parties says, hey, we need some help, things are going off the rails. Where that isn't feasible, either because of the nature of the situation or the cost, it still involves bringing in a neutral person, a mediator, with the skills to help the parties find a resolution. So as we know, a mediator's role is to assist the parties in their negotiation. The mediator doesn't make any decision. But having the person available, having the parties know that as part of what they're doing together, there is the way to deal with these situations other than to start documenting them, sending formal letters, putting them in minutes. It's sort of, take a pause. Let's in a more organized way try to resolve it.
Yeah,
And
sorry, go on.
no, I was going to say, I think parties who are trying to keep their projects going, keep their costs down, should be looking at these kind of options, training their people who are dealing with the projects to work with these kind of I'll call them dispute avoidance or early resolution mechanisms.
Great. I like the phrase relationships, human relationships, because disputes is usually when that breaks down. So how do we manage at different levels that relationship and keep people talking to each other with a common goal to, okay, we don't want this hardened into a dispute, so that we can continue with the project. Faisal, I turn to you because, again, you would also tell us what your company does. So what do you think? What for you are we talking about?
As you're surely aware,
okay?
the construction industry is adversarial by nature, and it in fact provides very fertile grounds for disputes. So eliminating disputes and conflicts is almost impossible. It's inevitable that you will have conflicts and disputes. It's all about trying to avoid and manage them properly. In my opinion, dispute avoidance and management is all about trying to handle conflicts in a manner before a formal dispute crystallizes, at which point resorting to formal dispute resolution methods becomes necessary. And of course, as you are surely aware, these come with their time and cost implications. Actually, from my day-to-day handling of matters with different parties, whether subcontractors, clients, or suppliers, I in fact find that the mindset of the individuals involved in a particular matter has a significant role to play in this. So the sooner the parties sit together, the more the costs are minimized, and in turn, the lesser the dispute resolution time and costs. In here, I would say it is essential, because of that mindset issue, to have people at leadership level who are willing to make decisions with a view to resolve problems. Because lack of leadership and decision making certainly does not help in dispute avoidance and management. In fact, if anything, it even adds more complexity to it. Early settlement, from my experience, is also considered a highly effective and efficient mechanism when conducted between senior executives. And I will elaborate on why I'm talking about senior executives. Of course, provided that they do possess comprehensive knowledge of the dispute and its circumstances, as well as the legal authority to resolve the matter and conclude a settlement on behalf of and in the interest of the disputing parties. This approach of referring the matter to the leadership of the parties stems from the fact that individuals and personnel that are most directly involved in the dispute, in the context of construction industry, project managers and engineers, may allow emotions to influence their stance because they are directly involved in the matter of dispute. So as a result of that, they tend to be driven by personal feelings. That is what I've observed. Then basically, failure to separate feelings and personal emotions from the substantive and technical issues at hand, they may then prioritize matters differently. Whereas, in contrast, when a dispute is managed by people who are distant from the matter and not directly involved in it, you find that a rational and objective approach will be more likely adopted, leading to early and rapid resolution, which of course helps both parties. But one point I'd like to reflect on: being a contractor, our objective is not only to win a dispute, because we always have to look about we have to look at the long-term relationship with a client. So, for instance, you might win the argument, but then lose the company or lose the client. So, unfortunately, in many instances, one have to make business decisions that may not be directly linked to legal position or legal argument or whatever, but this is because we want to preserve the relationship with the client. So we just end up making a business decision that is balanced based on calculated risks and move on with the situation. So from a contractor's perspective, I think both are equally important: managing the relationship as well as the dispute.
Thank you very much, Faisal, for reminding us again that businesses, we say that for a lot of commercial entities, disputes is not their core business. The core business of disputes lawyers is disputes. The core business of construction companies is to find business, work to construct. So I like this idea of keeping in mind and in view long-term relationships. And at Gar Life Energy, we had the senior law person, and he said exactly the same thing, that of Chevron, and that they're quite keen on preserving their long-term relationships. And so you might have you might give up something now, but with a clear view of what you can get
I'd
in the
like to add
future.
one additional note, if you don't mind,
Yes,
Professor
please.
Emilia. So for construction contractors, unlike solicitors, arbitrators, or judges whose core business is dispute and dispute resolution, in fact, that isn't the service that we sell. We sell construction services. So that's why we always look at our core business as the main priority. And if there is one point I'd like to add, I actually find in relation to early settlement that when you engage the lawyers early on in the process, that doesn't always help. Because
I thought you were going to say that helps, because Terry was already smiling that, yeah, he gets it. But anyway, go on. Why doesn't it help?
Okay. I wouldn't say that this is always the case, but I'm only reflecting on my experience.
Yes.
I would always recommend not engaging lawyers at the early stages of early settlement. And that is for one very specific reason. It is conflict of interest or self-interest. So basically, if you engage a lawyer early on in the process, and then the lawyer suggests that, you know what, you don't really need to go to arbitration, you don't really need to go to litigation. This is an easy dispute. We can just resolve it through a settlement agreement. Then there is always that one thing in mind, loss of revenue. And from what I've seen, some lawyers certainly do advise to the best interest of the clients. However, some don't. Therefore, I would definitely recommend not engaging lawyers early on in the dispute process or in the early settlement.
Okay, Faisal,
I think
you want
Amira's
to
got
cause a
something to say about
storm.
that.
Yes, some people are raising
Or,
their hands.
yeah,
I'll come
maybe
to
just
Terry.
pick the right lawyer.
I strongly disagree with
I
that.
know
It
that you're
depends.
going
It
to. I
depends.
know
It
you
depends on
strongly
the
disagree.
lawyer.
I know, Amira. But, okay, so let's bring Terry in, because Terry she smiles,
support me.
then she frowns her face, then she smiles again. So she has a lot to say. So Terry, let's hear your rebuttal of Faisal's points, and then Amira will come on board and Barry will close us out. Terry, please.
Thanks, Emilia. So I would, as expected, slightly disagree with Faisal on that. I do think that dispute lawyers particularly could have a benefit in trying to identify what the issues of contention are and move to getting the parties to a position that can actually unlock the issues. But I do also appreciate that Faisal's lived experience might be slightly different. I do like what my colleagues and the panelists have said about dispute avoidance, and it really is the same things, starting with you, Emilia, when you said that it's about clearly defining what the contractual terms are. It seems like an obvious point, but often what I see in matters that land on my desk is that when the marriage or the courtship is quite, enticing and exciting, people assume that things will always remain that way. And it is only when things go south that, with the benefit of 2020 vision, that people realize that there are certain clauses or certain considerations that were not captured at the onset. So whilst, as we've all said, and I think Barry highlighted about the neutrality, it's also important to understand that things can go wrong and sometimes horribly wrong. That is where external persons, not necessarily the technical experts, come in based on disputes that we've seen where we've assisted clients. We may actually point out things that a client has not thought about. So for example, if there are regulatory issues for an investor or a client who's coming into this side of the world for the first time, it may not be top of mind for them, but we would be able to flag some of those things. So I'll just quickly go, because just looking at the clock, I think we may be challenged on time. But nipping it in the bud, as Barry said, I think is the second thing I would say about, when we see that the things starting to get rocky, what we want to do is quickly come in and see how to stop the bleed. And that may, in different scenarios, present itself differently. So as Faisal would say, perhaps trying to contain it in-house and identify whether it's a C-suite discussion or a technical experts discussion. What are the critical issues? What can we agree on? What needs to be decided, or what requires external support? But the reality, and I like what Faisal has said, that sometimes parties often have to make business decisions as opposed to legal decisions. And sometimes looking at the commercial relationships, the need to continue some of these engagements with a view to having more projects may result in a decision being made perhaps in a different way than the legal scenario may present. And of course, emotions influence us, as has been spoken about. But generally what we are seeing in our side of the world is that parties are definitely becoming more deliberate about dispute resolution mechanisms that allow for quicker resolution, as opposed to a knee-jerk reaction of something is going wrong, let's either go to court or let's invoke the arbitration agreements. And so project agreements are increasingly being more technical than one would have seen perhaps, maybe 10, 15, 20 years ago. And I think that's speaking more to the collaborative efforts that we are seeing even within our clients, where there's a more multifaceted involvement in the drafting of contracts. And I think that is also aiding to mitigate against the contracts that we have perhaps seen coming up traditionally. So I would say in closing that the expert determination, of course, is one way of mitigating against the disputes. And I like what Amira said about the avoidance of issues versus dispute mitigation. In the reality that disputes will always happen is something that sometimes parties don't always get right. And I like the conversation we're having today, because we're not saying that disputes will not arise. What we're saying is that disputes do arise, but how we respond to those disputes, whether legally or technically, can then help in resolving the dispute in a manner that is cost effective and fits within the bigger picture of trying to make sure that the project is not compromised. Thank you, Emilia.
Thank you very much, Terry. And I want to turn to Amira. I know you want to respond. Hopefully, Terry has picked up most of the things you want to say. But I wanted to ask you that maybe in your response, let's kick off and move on to the tools, because effectively
Yes.
we've started talking about the tools.
Exactly.
So please.
That's what I was going to say, because to respond to Terry's and Faisal's intervention, we are actually now talking about the tools, and the most effective mitigation tool is designed in before anything arises, actually. So let me take you across the whole timeline of a project so that we show to Faisal that the lawyer can intervene positively also. But I agree with you partially that a lawyer should not in all cases intervene. And there is a point where he is more useful. It depends on his practice. But before the disruption, it's all about the contractual architecture, actually. So you have many tools, and most of those tools are not the legal mechanism at all. Whether you are using the escalation clauses that require senior negotiator, or you have also the governance or the steering committees that should be meeting on a fixed cadence. You have dispute boards or DAB standing that is ready in the room before there is a dispute. You have clear reporting mechanism that you could use, periodic commercial reviews built into the contract. All these tools can be helpful before the disruption happens, as a first red flag. And during the disruption, what you need is what you said, Faisal, is keeping the relationship intact. Okay, we have a
Yes.
conflict. We have a conflict, but conflict is not a dispute. Everybody can have a conflict. Okay, even brothers and sisters have conflict. So conflict is it's the nature of life. So during the disruption, you can work out some other tools like hardship and the other structured renegotiation tools or protocols in the contract itself, or executive escalation to senior, which you have already said. But and here I have to point out that the decision makers are far from the people locked in the daily conflict, so they can have a somehow neutral position to cool off the whole situation. So this is before and during, and then before a formal proceedings, you have, of course, the mediation, expert determination, or any neutral evaluation. But 2 points to close on. First, and here what you were saying about the lawyer could be interesting to link to. By the time lawyers are asked to solve the problem, several of these opportunities I have cited have often already been missed out. And second, the effectiveness of every one of these tools depends on a cultural variation, whether the parties treat an adjustment request as a cooperation or as an attack. So there is the culture, which is linked to the communication, and you have at which point you involve the lawyer. Maybe if it's a transactional lawyer, you can involve him or her right before even the disputes really arise, so that you can handle the relationship at the same time. So a good escalation clauses mirror that architecture. But for a cross-border African and Middle Eastern project, I would add even three things: to appoint the neutral body at the outset as a standing board rather than an ad hoc, so it's already in the room; to make the first tire mandatory and time limited, so it's not skipped the moment tempers rise; and third, align the mechanism with the local enforcement. This is the last point, is exactly what Terry's Kenyan example explained, where a DAB decision needs the contract to confer high court jurisdiction expressly to be enforceable. So any elegant sequencing means nothing if the outcome cannot be enforced at the seat. So these are some mechanisms that you can use on a contractual level and out of contractual level on a social level. But you have also on when it comes to investment disputes, you have other mechanisms. You have host state domestic mechanisms that can be put in place to avoid conflicts to go beyond a small conflict. We have Egypt that offers a useful example, like the GAFI's Investor Dispute Settlement Center, that has provided mediation for investors for investor disputes since 2009, and the investment law of 2017 that established both a ministerial committee for investment dispute resolution and ministerial committee for investment contracts dispute settlement. The latter may, with parties' consent, to restore the contract balance and extend deadlines and reschedule financial obligations. So it's an institutional mechanism for preserving an investment relationship before it becomes an arbitration. And of course, as all you know, we have also, beside the contractual and domestic mechanism, we have on international level some examples like the work of the UN Central Working Group 3 that has few days ago finalized the draft of the Advisory Center on International Investment Disputes. So this is the purpose is intended to support states, particularly developing countries, and it will not by any means be replacing the project level tools or the domestic mechanism, but it can strengthen the state's ability to recognize a problem early on and coordinated with the counterparties. So to respond to the question of how what are the tools, we have actually plenty of tools, and to build on Faisal ideas also. Well, on these projects, we the written contract is really the whole agreement. We have a relational layer, and when the disruption hits, how a party raises the problem, it will matter. It will matter as much as the clause it relies on, because a well-drafted escalation clause still fails if the first letter is read as a threat. This is for sure. And this is pointed out now through all the instruments, whether ICC 2020 hardship clause, the UNIDROIT, FedEx, DAB, all say renegotiate first, educate last. And in our region, this is how business has long been done, actually. The task now is to write it into the contract, as Terry has said. So it survives a change of person or a mood. And it is not new to our region. It is native to it. Islamic law has always recognized the impartial mediator, sulh, wasata, and treated it not as a second best scenario option. No, it was a favored way to resolve disagreement precisely because it preserves the relationship. So I'm not gonna take longer than this. We are not importing a foreign idea, but we have now to writing down something the culture has always valued.
Okay, thank you very, very much. So what I have heard so far since we started is this whole idea of its relationship is important. Early nipping things in the bud. I think you've all mentioned the phrase. So early detection, what we mean by a dispute, keeping track, what is going on, and engaging early. That's the message that the panel is sending out. The other message that the panel is sending out is the use of more formal mitigation processes, like, early mediation, DABs, dispute boards, what can be done, making sure you have a standing group of neutrals that can engage. Faisal said something that I think is really, really important: the feelings, the people that are not feeling, they're not feeling it, and that's what lawyers do. We don't have commercial lawyers don't have feelings. It is so we get on with it. And I think we understand that. I think those are really, really important points, and what
Emilia,
states are doing.
if you
Yes,
don't mind,
Faisal,
please. I'd just like to add one final concluding remark, very brief,
okay,
in relation to what Dr. Amira said.
yes,
So
you want to respond?
Yes, I'm
Yes.
definitely with the introduction of multi-tier escalation clauses into contracts. These are excellent tools to make sure that disputes don't eventually have to go to the final stage of whether arbitration or litigation. However, from experience, very recently, I would always recommend restricting each stage with a certain time frame. Because if there are no time frames, and then eventually the dispute goes to arbitration or it goes to litigation, these steps could be seen as conditions precedent to arbitration, and then the arbitration committee may actually choose to refer the dispute back to that stage where it should have been in. And some parties, unfortunately, may intentionally prolong the process if there is no time frames.
Yes, I think that is a point that is well taken and understood. Thank you very much, Faisal. I want to turn to Barry and Terry. Is there something we haven't mentioned that either one of you is burning to talk about that as part of how we mitigate this? Terry, Barry, anybody? Is there anything else that you would want to add that hasn't been mentioned? Because I really want to go to AI. I want us to see how AI can support this. Is there anything else?
Terry, you want to go first? Or?
Yes, if I may. Thank you, Barry. I would say, Emilia, the importance of having local knowledge. Because giving a recent example, the practice in Kenya has been where the disputes, particularly in the building and construction industry, there's a certain tiered approach, picking up from what Faisal has said about how disputes are handled. And the approach has been that the courts or the High Court has taken the position that those matters don't need to go to arbitration and that the courts have jurisdiction to deal with them. But the recent decision held that even despite the fact that the party's intention was to have a technical expert make a determination on the issue, the courts have now said, and I think it was a decision of the Court of Appeal, the Court of Appeal has now said that it does not have jurisdiction to undertake any enforcement around those decisions, and that parties have to go to arbitration. So Faisal has, of course, very excellently pointed out the importance of having a multi-tiered approach. But I think even in considering that, the local circumstances need to be considered. So that, for example, if I was advising a Kenyan client, I would say, you now have to think critically about the multi-tiered approach, because in Kenya, the position is now that you will have a technical expert decision on the understanding that it will be a quick dispute resolution approach, but the courts have now said for enforcement, you still have to go to arbitration, so that you have to be nimble and have to take the approach that best fits with the local circumstances. Thank you, Emilia.
Thank you very much, Terry. It'll be interesting to read that decision of the Kenyan courts, because to understand the reasoning behind it, or maybe it is that a technical expert's decision is not an award, which can then get to the courts for enforcement or challenge. It will be interesting to understand that. But thank you very much for bringing that to our attention, Barry. Did you want to add anything else before we move on to AI?
Well, I just want to reinforce, and I've been having this in the chat with Mohammed and Ben, both reinforcing the point about having a good lawyer or an experienced lawyer. And I think it's, Faisal's point is a really good one, an important one. But I would say that, he's in the fortunate position of being able to choose his lawyers. And if you can get and you should be retaining somebody who has the right approach in terms of, and it may be more difficult, but the worst thing when you look at a dispute and you see the first thing that a lawyer does or has done is write a demand letter, pull out form number, whatever, and just putting, salt in the wound. Whereas when you've seen an experienced lawyer, not whether a transactional lawyer or a disputes lawyer, I had experiences of watching some, fabulous transactional lawyers who would just become in a mediation type role with the person on the other side, and realize that the role of the lawyer is not to turn it into a dispute or a litigation or arbitration, but to find a solution, or to help the parties find a solution. And then fortunately, there's lots of lawyers around, and the lawyers who have the attitude that they're going to lose revenue ultimately are going to become unsuccessful, and because it's just in the world as it's evolving, you need lawyers who are going to help resolve disputes, help avoid disputes.
Thank you very much, and I am very pleased to see that we have very interesting engagement in the chat, and one of the things that in-house counsel may think about is also clearly setting out the parameters for the external lawyers and saying to them, we would like to take it easy. We want to see if we can resolve this. Because I think the concern that maybe Terry and Amira may have would be conceding things that there's no guarantee that the resolution would stand, or you would even get to a resolution, and then you get to a point where you've made concessions that you don't need to make. But of course, let's not forget that companies are not all the same. So Faisal company, for example, has him in-house. They have a large law department, but SMEs, quite a number of small-sized companies might not have any lawyers at all. And then, we know what the concerns and the problems with those would be. But moving on to AI, how do you think, and I need each of you to say something in like 1 second or 5 seconds. How do you think AI might help with dispute avoidance? Who wants to kick? Faisal,
let's you want to start with?
With you, Faisal. Let's start with you.
Okay. Thank you. So AI has recently become the hype of the world. Everyone is talking about it and all of that. I personally do not encourage the overuse of AI, especially for students. This is my personal opinion, and I'll explain exactly why that is the case. And it is based on my teaching experience. The reason why I believe this is the case, and I strongly believe in it, is because the process of finding out about any piece of information and the information you come across in that process forms a great deal of one's knowledge. However, when a piece of information through AI is presented readily, without research and finding out, you do tend to lose in that aspect. The human brain is a muscle. If you don't use it, you lose it. So you can't basically substitute your brain with AI. That is one. However, even though that is what I have said, and we have to look at the word overuse. So I don't mind using AI, but I do not encourage overuse, especially by students who are still in the process of accumulating knowledge. That said, as we said in the past, that proper contract administration is an effective means of managing and avoiding disputes. Because of the volume of construction contracts that can be very significant at times, in reality, in certain instances, these contracts can be in the range of thousands of pages when I'm talking about big mega projects. It is almost impossible to remember every single entitlement and obligation of the parties. Therefore, in my opinion, and that is something that I've always emphasized on here in MBL with my team, the best way to prepare for contract administration is to develop what I refer to as a schedule of the obligations of the parties. This schedule summarizes the contract, so you can basically refer to it as and when required to remind you with the obligations and entitlements in each clause. I want to very briefly tell you how we do it in practice and then how AI significantly helps in that. So this is where a schedule is drafted with the clause number, a description of what the clause says, then the obligation and or the entitlement in that clause is extracted and registered under the relevant party. Typically in construction contracts, you've got the contractor, the employer, or the engineer in FIDIG. They call it the architect in JCT, the Joint Contract Tribunal in NEC, they call it the project manager, contract admin. So following that, you will have the time frame for compliance in one column with that particular provision, then finally a column for remedy of breach. So basically, this is a full summary of all the entitlements and obligations of that few thousand pages contract. So for instance, if the employer does not provide the site within the specified time frame, and in the column you have the number of days, then the remedy for breach would be that the contractor shall be entitled to additional time and or cost. The preparation of such documents can take tens or maybe hundreds of hours, because you have to go through every single clause to extract the obligation and register it. Through AI, this task may be carried out in no time, really. And that is something we have been doing here in MBL. Then, subsequently, AI may be programmed to highlight obligations and entitlements as and when they arise during the course of the contract. For example, through scanning of correspondence. If AI is programmed in a way to scan correspondence and flag the entitlements and obligations of the parties, then this provides contract administrators with sufficient notice to take the right contractual appropriate action. And that is especially in relation to time bars, conditions precedent, and conditions subsequent. With AI, all of that process that takes so many resources and hundreds of hours sometimes, AI can help you to do that very easily in terms of pre and post contract work.
Oh, okay. Faisal, I have my eye on the clock and we have overrun. But the point you're making is that that's the project, if you like, platform. AI helps to with tracking of various tasks, and then it becomes easier if there is a dispute, disagreement to track back, and then those can easily be located. Okay, fine. Thank you very much. So that's that angle. So let me, everybody else, you have less than 10 seconds left. How do you, what else can we use AI for? Barry, less than 10 seconds.
I think the other use for it, and or maybe just picking up on what Faisal was said, is to help us identify emerging problems. So it's to do what the parties on their own may not be sensitive to. And so it can identify from the communications, from what's going on in the project, things that historically are associated with leading to disputes. And so developing the use of AI really as an early warning system to spot things that the human eye isn't spotting is one way in which it could be helpful.
Yeah, great. Terry.
Thank you, Emilia. Faisal has beaten his drum about the dangers of AI, which I think we all agree with. But I would also have one other cautionary comment. We know that a lot of these AI models are trained on data from, certain regions of the world. So for example, if you're going to deploy those tools in Kenya, they may not necessarily be fit for purpose because of, certain biases or the data that's used to train them. And of course, they may not necessarily be able to help with the cultural, regulatory, or legislative landscape. So I would say, of course, as Faisal has cautioned, the human input is always important, despite the fact that they would, of course, always be helpful to go through or to help with the management of a lot of documents. Thank you.
Thank you very much. Amira.
Well, very briefly, of course, IA is very helpful, but it has its limitations and risks, of course. And IA can identify risk in the contractual or in the legal, within the legal dispute framework, but it cannot rebuild trust. So the main idea is, yes, AI generally helps. It can monitor contractual big volumes of documents, recordings, and flagging inconsistencies. This is for sure is a big asset, but it will not solve your problem. It will help you to detect the problem, to flag it out. But most project disputes actually do not rise because the parties lack information. So IA is good for maybe giving you the information, but not to resolve the dispute. They arise because communication breaks down. So AI is good for the information, but the rest, it's really a matter of communication and the decision to renegotiate or to compromise to preserve a certain relationship rather than win a point, it will remain profoundly a human decision. So,
Great.
so
Sorry.
use no. So use AI to see the problem earlier, but do not expect it to make the human choice that avoidance ultimately requires.
Perfect. So I told you all that you would have a wonderful time, and you can see that the panel, they're still, I'm sort of holding them back because they still want to keep going. But we want to hear some voices. We're very grateful that there's been great interaction in the chat. If anybody has a question, a very short comment that they want to make, the panel will be very happy to hear what you have to say, and they will try to answer your questions.
They
And you
need
can
to,
just, sorry, please go.
they want to kill the lawyers.
No, Faisal is also a lawyer. So yes, Faisal, yes, so he's part of us. And so what the panel, I'm just going to try and quickly did you want to say something now? Mohammed, did you want to come? Did you want to?
Yes, I am really inspired by this session. Honestly, this is one of the best sessions
Please, can you put
attend.
it in writing? Can you write it so our bosses will know that that the webinars are useful? Please go on.
Okay. I will share it to my LinkedIn. Is it okay?
Yes, of course. Please don't listen to
Yeah.
me. Please go on.
No, this is one of the best session I attended online. Honestly, it inspired me towards my LLM in the United States on international arbitration and business law. Almost all the speakers, especially, in fact, no exception, all the speakers have done a great. I am most grateful. Thank you so much.
Thank you very,
Wait.
very much. That's very kind. I see that some cameras have come on, some videos on. Does anybody else want to quickly say something before we summarize? We still have like 5 minutes. Anybody? Mark, please.
Thank you. Thank you so much, Professor. And thank you to all the panelists. I'll be very brief. I'll go straight to my question. I know we're over time in case others want to communicate, but as was just said, this has been a very, very fantastic panel. I just wanted to touch very quickly, on all your expertise as it relates to this idea of early mitigation through formal mitigation techniques. So, for example, through mediation. In a situation where the mediation or any other formal technique is not successful, do you find then that it tends to serve as a hindrance? Because obviously then this will lead to more time to resolve, what will now be a dispute, a full-blown dispute, and also will increase the costs. So would you say at point it serves as a hindrance, or does the overall idea of trying to nip, any dispute in the bud, does that serve as the overarching aim that we should look towards, despite any inconvenience it could cause if not successful?
Thank you very much, Mark. Is there any other questions so we can collate all the questions for the panel? Going, gone. Okay. So panel, can we try to? We have 2 minutes. Let's try. Who wants to kick us off with an answer?
Why don't I start?
Yes, but
Mark, I don't think it's a waste of time or money at all. First of all, mediation may not produce a resolution, but it's also not a one-shot deal. So there may be a mediation, it doesn't lead to a settlement, but the parties get a better understanding of each other and then later on resume. Secondly, it may narrow the issues. So the parties, if done right, the parties may be able to say, okay, we can't settle it, but we know that we only need to deal with this issue in our adjudicative process. So sure, it needs to be, it does add to the cost, but significant costs are really going to be incurred in the adjudicative process, whether in court or in arbitration, as compared to the mediation.
Thank you very much, Barry. Terry, did you want to add something?
Yes, very briefly. Thank you, Mark, for your question. I think this really then goes to testing the good faith term that's used in a lot of these dispute resolution clauses that we see. I really do think that the direction that's taken in this attempts to mediate or negotiate matters before they escalate depends on the meeting of minds in a manner that really demonstrates that the aim or the intention is to resolve the issue. Because absent that, then you find the combination of bad faith, a lot of emotional investment, does actually take away from the idea, as you mentioned, of wanting to resolve the issue amicably. So I would say that absent good faith, it can actually be a hindrance to the dispute resolution that's intended. Thank you.
Thank you very much, Terry.
Sorry, guys, I just got disconnected for a couple of minutes, so I wasn't really following if any question was addressed to myself.
Oh, no, it's a general question addressed to everybody. Thank you, Faisal. Amira, did you want to say something? Okay. Is that a no? Okay.
No. It was muted actually. I think Terry and Barry responded very well to this question. I was trying to see if there are other questions in the chat, but apparently there are not.
But there's a lot of good feedback in the chat, so thank you all.
But there are, very good feedback and very interactive. Very good.
I like the idea. Yes, I like the idea of people using the chat. So thank you so very, very much for doing that. So what have we covered? Because sometimes you might attend a class and the class lecturer is very, very engaging, and you then feel that it's really interesting. And after 5 minutes after the class, you can't remember anything that was said in the class. So one of the things, I think, a couple of takeaways. One of the things we've sort of really focused on is that distinction. At what point do you get to dispute? The need to ensure that there's that continuity of engagement and understanding what the core business of your client or of the company is.
Absolutely,
And how can we support them with that? And the other thing that we sort of tried to engage with is we also mentioned things around, I like the idea of feelings, and it's because those who are engaged, particularly involved in delivering the project, have invested their time, they've invested their knowledge, their emotion, and things like that. And so, which is why the feelings become raw. And so it's trying to ensure that we're able to disengage the feelings part of it. I think, and Barry does more, and Amira, they do more mediation than I do. But I think that there's a place for feelings as well. Because in mediation, sometimes it just is, all it requires is an apology to just, or to a clarification that that wasn't what I meant or something. And that assuages the other party. But the key message we want to leave with you is that dispute avoidance, dispute management, dispute mitigation is really important. And we hope that the other issues we engaged with, that there's something for you to take away in your own practice. And I think the view of the lawyers, all the panelists are lawyers, is that you still will make some money so that the lawyers don't go away feeling we want to take their work away from them. Terry is nodding, so it means that yes, you would still make some money, and your clients would get more work done. So can we then show our appreciation to the panelists and say a huge thank you to them?
Just if I would like to leave just only one thought before leaving, is
Yes.
that this is the only takeaway from my side, is most disputes are not lost on the merits. They are lost in the first exchange and how the first request to adjust whatever situation is written. So it's really all about communication and handling that one moment. And in our region, it's not a new idea, it's an old one, and we are simply learning how to write it in our contracts.
Thank you very much. So thank you, everybody. Faisal, thank you. Terry, Amira, Barry, thank
Most
you
welcome.
so very, very much. And we would see you all again on the 20th. Sorry.
And thank you for the audience. Thank you, Emilia, so much, and for SOS for organizing this webinar. And thank you for all the speakers and my colleagues.
Thank you very much.
Prof, I'll end your conversation by saying thank you so much for bringing together this wonderful team. We really enjoyed their submissions. Thank you.
Thank you, everybody. We can
Most
stay
welcome.
here and
Been
keep
a
saying
pleasure.
thank you until another 30 minutes.
No, but there's
So-
one other important thing to say, and that's have fun tonight wherever you're going, Emilia.
I was going to say that. Have a lovely dinner.
I will. Thank you very much. Bye, everybody.
Welcome.
Thank
Bye-bye.
Thank you.
Bye.